There's a public hearing this afternoon in Jones versus Abel, which is a separate but related case to Lively versus Baldoni and Wayfarer. This comes from the Jones parties trying to basically reopen discovery to get more information from Katie Case, a third party who was a former employee, or maybe even a current employee, I'm not sure, of TAG, the crisis PR firm run by Melissa Nathan. We all know that Jennifer Abel has disputes with Stephanie Jones over her taking her phone, allegedly holding her phone number hostage, improperly taking all of her communications off of that phone, and then giving them to Blake Lively under the table, which is why, allegedly, Blake Lively then filed a fake lawsuit under one of her shell companies, Van Zandt, to serve upon Stephanie Jones and make it look like these things were obtained through a valid legal process. But there seems to be a separate feud with Melissa Nathan and Stephanie Jones that far predates any of these lawsuits, because Stephanie Jones really did not want Jennifer Abel to bring Melissa Nathan and TAG on to help with the Wayfarer account's crisis PR. Even though Stephanie Jones was barely involved with their account at all, it only sought to insert herself when shit was already hitting the fan and ended up making it exponentially worse. So here's the current issue. Remember, this is filed in Jones versus Abel, which is why it's so bizarre that Blake Lively has decided to insert herself. This is a separate case in which she is not a party. And I think just sort of reinforces the idea that Stephanie Jones and Blake Lively have been working together. Stephanie Jones and JonesWorks are saying that Katie Case, one of the former employees of TAG, has not produced responsive materials to the subpoena they served on her. This is apparently because the Wayfarer parties interjected with objections to Case's production. Now, the issue at hand here is that they're saying Katie Case, at Melissa Nathan's direction, had something to do with the Stephanie Jones Leaks website and tweets from a disparaging Twitter account. None of this has to do with Blake Lively at all, and to be honest, I sincerely doubt anyone would have given any real attention to these things if Stephanie Jones wasn't bringing them up in a lawsuit. It seems like something that would have easily blown over, but Stephanie Jones wanted to go scorched earth, as we've all seen. I'm just not sure how this is going to pay off for her, because even if she could prove that these people were involved, and mind you, this is a former TAG employee, so this has nothing to do with Justin Baldoni, and quite possibly nothing to do with Jennifer Abel, or anyone else on the Wayfarer side, other than Melissa Nathan, allegedly. I think she's going to have a hard time proving damages from a Twitter account that says bad things about her. I mean, come on, lady. But, all right, if that's how you want to spend your time and money, I guess. So we're going to get into the details of all of this later on, maybe tonight. But right now, I just wanted to kind of broadly talk about what's going on and then why Blake Lively inserted herself and what's going on this afternoon. So here's where Blake Lively kind of weirdly got involved. It says, Plaintiff Blake Lively respectfully writes this court in support of the motion of Stephanie Jones and JonesWorks, seeking that this court compel third-party Katie Case to produce relevant non-privileged materials in response to the Rule 45 subpoenas served on her. The documents sought by the Jones parties should have been produced to Miss Lively months ago in accordance with this court's order. Instead, Miss Lively only learned of their existence when Miss Case confirmed that she possessed and agreed to produce certain documents in response to the Jones parties' supplemental subpoena. Lively respectfully submits that the documents the Jones parties seek are highly relevant to the above-captioned matter, as they will meaningfully assist the jury in assessing the credibility and truthfulness of key witnesses at Miss Lively's fast-approaching trial against the Wayfarer defendants. So I'm not sure this makes a whole lot of sense. Blake Lively is not a party to the Jones versus Abel case. She doesn't have a right to request anything in that case, to my knowledge. And there's nothing to really show that the stuff that she's asking about is relevant to her claims, other than she said they are, which you're going to have to forgive me if I don't find that to be the most reliable source of information. The anti-Stephanie Jones Twitter account and the Stephanie Jones Leaks or Lies or whatever it was website doesn't have anything to do with Blake Lively's claims. So the subpoena in question that Katie Case was ordered to respond to produce all these documents in response to, asked for documents and communications concerning this digital campaign, which was defined as efforts of the Wayfarer defendants, including TAG, Nathan, Wallace, and Street Relations. Remember, Wallace and Street Relations have been dismissed entirely from Blake Lively's case for the second time now, and they're not going to be brought back in. Okay. So the Wayfarer defendants' efforts to communicate information regarding the actions on any social media, news outlets, or other internet platform, and the actions are referring to the cases in Jones versus Abel, as well as the factual allegations or claims contained in all pleadings. The complaint filed in the Jones action is replete with factual allegations and claims related to the creation of a derogatory website relating to Miss Jones, as well as the placement of the Business Insider article, Who's Afraid of Stephanie Jones? Bringing claims against unknown individuals who created and published the defamatory websites StephanieJonesLeaks.com and StephanieJonesLies.com, both of which have now been taken down, by the way. When I first started following this stuff, Stephanie Jones Lies was still up, but it's gone now. As well as more than a dozen fake social media accounts and dark web accounts that defame Jones and JonesWorks. So this is what I'm saying when it comes to Stephanie Jones and this kind of scorched earth litigation that she's doing. Like, which of us doesn't have fake social media accounts that are saying some shit about us? Like, I'm a fucking nobody, and I get the craziest people come out of nowhere and say the weirdest things to me and about me. Am I going to enter into litigation with these people because my feelings are hurt? And spend hundreds of thousands of dollars on attorney's fees over what literally amounts to nothing but hurt feelings because I can't prove any damages? I don't think that's really the best road to go down, but Stephanie Jones doesn't strike me as the most stable person on the planet, so I guess that tracks. So here's where this gets really, and this is still Lively's letter, so here's where this gets really dumb to me. Ms. Keys's recent apparent agreement to compile and produce documents to the Jones parties regarding or relating to any websites or social media posts concerning or relating to Stephanie Jones and or relating in any way to what ultimately became the Business Insider article now confirms that there are documents responsive to Ms. Lively's document requests that were improperly withheld. How is information responsive to a subpoena about StephanieJonesLeaks.com relevant to Ms. Lively's claims, first of all? And second, how would that information be responsive to Miss Lively's document requests? They were required to respond to the subpoena with certain documents, information, whatever, within certain parameters or keywords. They don't have to send you everything they've ever written. And she says, to the extent those documents were sent to or from or copied Melissa Nathan or Jed Wallace, those documents would not only be responsive, but potentially further evidence of spoliation by Miss Nathan and or Miss Wallace. Blake Lively is trying really hard to convince people that evidence must have been deleted because she can't find any evidence of a smear campaign. So it couldn't be that she should finally face the consequences of her actions and accept that people didn't like her because of the way she conducted herself as the film was being promoted and then her past behavior came to light. Now, we don't want to do that. Instead, we'll just assume that there must be deleted evidence. Anything but self-reflection. Anything but self-reflection. Like I said, I'm not going to read everything right now. We'll get into more of that later, but right now I just want to kind of go over this broadly. This is from Katie Casey's attorney in response to Miss Lively's letter. Okay, it says, we respond to Miss Lively's untimely response to the Jones party's motion to compel, on which the court has now set a November 24th, 2025 hearing, solely for the purpose of correcting the record. The central position of Ms. Lively's submission rests on her counsel's assertion that Ms. Case's potential production of additional records confirms that there are documents responsive to Ms. Lively's document requests that were improperly withheld. That averment is incorrect. Following extensive negotiation and motion practice, Ms. Case conducted a review based upon agreed search terms that were applied to agreed sources and to a date range set by the court. Ms. Case produced all responsive non-privileged documents identified through that process. The assertion that because additional potentially responsive records may exist outside of those parameters, Ms. Case somehow withheld records is thus untrue, as Ms. Lively's counsel knows, or should know. And then the Wayfarer parties also responded to Lively's letter, saying Ms. Lively has filed a robust letter in support of a motion filed by another party in another case in which she is not a party to compel compliance with a subpoena that she did not serve. Ms. Lively lacks standing to enforce the subpoena to Ms. Case because she did not serve it. The crux of Ms. Lively's contention is that documents sought from Ms. Case are needed to discredit Melissa Nathan because, according to Ms. Lively, Ms. Nathan's deposition testimony cannot be reconciled with Ms. Case's deposition testimony. Ms. Lively does not explain how any difference in the testimonial evidence concerning Stephanie Jones leaks or any other website is relevant to Ms. Lively's claims or the defenses thereto. Moreover, the use of discovery to establish credibility and gather information for impeachment is limited, especially when the witness, Ms. Case, is a non-party. Ms. Lively further argues that the alleged existence of documents concerning websites or social media posts related to Stephanie Jones confirms there are documents responsive to Ms. Lively's document requests that were improperly withheld. Yet Ms. Lively neglects to explain, let alone demonstrate how that is true, fails to attach her own document requests, and confusingly cites to a subpoena she did not serve. The JonesWorks motion to compel should be denied for the reasons set forth in the submissions properly filed by Ms. Case, as well as by Wayfarer Studios. All right, so I highlighted right there. There's a hearing this afternoon. Anyone who wants to dial in can, so you can just pause this screen and write down this information. But that's all I got for now, guys. So thanks for watching, and I'll talk to you later.